This presentation will deal with the area of freedom, security and justice and look at how the EU aims to secure free movement whilst at the same time combating illegal activities. This presentation is by Claire Bradley, Director, Europe Direct, Eastleigh. So first of all, what is the area of freedom, security and justice? So as part of your free movement rights, every EU citizen has the right to move freely across the EU. However, free movement of people also means you can get the free movement of criminals. To counter this, it came to be recognised that judicial and police authorities across the EU needed to work together to prevent abuses of the free movement rules, and this led to the creation of the area of freedom, security and justice. The provisions relating to the area of freedom, security and justice are therefore a flanking tool to deal with criminal abuses of the free movement rules. So what does the area of freedom, security and justice actually cover? It covers the management of the European Union's external borders, so things like visas into the EU, judicial cooperation in civil matters, judicial cooperation in criminal matters, and also includes asylum and immigration policies, police cooperation, and the fight against crime, so things like terrorism, organised crime, trafficking in human beings, drugs, etc. The area of freedom, security and justice comprises Title V and the Treaty on the Functioning of the European Union, which is a key part of the Lisbon Treaty. Subject matter dealt with by these provisions is important and also politically sensitive. Judicial cooperation in criminal matters under the Lisbon Treaty. Now this covers things like the European arrest warrant, rights of victims of crime, mutual recognition of judgments in criminal matters, right to interpretation and translation in criminal matters so that you actually understand what's being said about you, procedural safeguards in cross-border cases. Another key principle is the mutual recognition of judgments in criminal matters, and this is a key aspect. So the European Parliament and the Council may lay down rules and procedures for ensuring recognition throughout the Union of all forms of judgments and judicial decisions, and also prevent and settle conflicts of jurisdiction, i.e. which legal system is dealing with the case, between member states. It also can support the training of the judiciary and judicial staff and facilitate cooperation between judicial or equivalent authorities of the member states in relation to proceedings in criminal matters and the enforcement of decisions. Article 82.2 of the Treaty on the Functioning of the European Union states that to the extent necessary to facilitate mutual recognition of judgments and judicial decisions and police and judicial cooperation in criminal matters having a cross-border dimension, the European Parliament and Council may establish minimum rules. Such rules shall take into account the differences between the legal traditions and systems of the member states and concern matters like mutual admissibility of evidence between member states, the rights of individuals in criminal procedure, the rights of victims of crime, and any other specific aspects of criminal procedure which the Council, as representatives of the member states, has identified in advance by decision. Now, the adoption of minimum rules at EU level does not prevent member states from maintaining or introducing a higher level of protection for individuals. All it does is lay down certain minimum standards which should apply across the EU. Judicial cooperation in criminal matters covers serious crimes such as terrorism, trafficking in human beings and sexual exploitation of women and children, illicit drug trafficking, illicit arms trafficking, money laundering, corruption, counterfeiting of means of payment, computer crime and organised crime. The treaty also provides for changes in crime. So if new crimes start to develop and these have serious consequences, then the member state governments can choose to work together to combat this new form of crime. For example, the development of the internet has led to new crimes being created, such as trolling, online child pornography, online scams, etc. And the treaty provides that if new crimes are developed as a result of, say, technological change, then the member states can work together to actually deal with those. If you'd like further information on judicial cooperation in criminal matters, then I would suggest you go to http://ec.europa.eu/justice/justice_index_en.htm. Intergovernmental cooperation to combat matters such as terrorism, cross-border crime, and deal with problems associated with external frontiers is not a new development. Numerous mechanisms for cooperation have been developed over the years. For example, the Treaty Group was created in 1975 by the Rome European Council in order to coordinate the fight against terrorism. Its remit was extended in 1985 to encompass serious international crimes such as drug trafficking, bank robbery, and arms trafficking. The countries have always worked together to combat this serious crime. It was the Maastricht Treaty that started to create the system we have now. At that time, the Member States wished for some established mechanism through which they could cooperate in the areas of common foreign and security policy and justice and home affairs. Member States therefore devised a decision-making structure that was more intergovernmental and with the other community institutions having either no role or a vastly reduced role. Now, major criticism of the pre-Lisbon system was that many of the policies under the Justice and Home Affairs provisions called for institutional provisions different from the intergovernmental processes that were already established, so it was very messy. Also, these areas are politically very sensitive and often have major human rights implications, and there was a perceived need for more openness and accountability. The 2009 Treaty of Lisbon created the area of freedom, security and justice. So the European Parliament and the Court of Justice gained a say over the whole area, which was a new development, while the Council changed to majority voting for the remaining police and judicial cooperation in criminal matters, which sped up the whole decision-making process. The Charter of Fundamental Rights also gained legal force, and Europol was brought within the EU's legal framework. However, the area of judicial cooperation in criminal matters is a very contentious area with important political and human rights ramifications. Some countries are very keen on judicial cooperation in criminal matters, whilst others, notably the UK, Ireland and Denmark, have historically opted out of police and judicial cooperation. To counter this, the Treaty of Lisbon provides for enhanced cooperation. What this means is if at least 9 Member States wish to create a draft directive which would affect fundamental aspects of the Member States' criminal justice system, then those countries can use the enhanced cooperation procedure if they wish to do so. That means it would just apply to those countries that signed up to it. However, the legal framework is somewhat messy as a result, so some countries have opt-outs, for example in relation to Schengen, which the UK and Ireland are not bound by, right? But even though they're not bound by the rules on that, known as the acquis, they can opt in to all or part of Schengen subject to a decision in favour by the Council, acting with unanimous approval by the other Schengen states. Denmark is also subject to a special and rather complicated procedure. Norway and Iceland participate in the Nordic Passport Union, with Sweden, Denmark and Finland, even though they're not EU members. They also participate on a different basis in the Schengen system. So Schengen is where, once you're in the Schengen area, basically you don't have to show your passport to the borders of any of the Schengen countries. You can just travel on through as if you're just going from one to the other. The new accession states are countries that are in the process of joining are subject to complex provisions. So in relation to Title V of the Treaty on the Functioning of the European Union, the UK and Ireland have an opt-out with certain possibilities for subsequently opting in. Denmark has opted out of the provisions of Title V altogether. Now, The role and structure of Eurojust is mentioned in Article 85. Eurojust's mission is to support and strengthen coordination and cooperation between national investigating and prosecuting authorities in relation to serious crime affecting two or more member states, or requiring the prosecution on common basis, on the basis of operations conducted and information supplied by the member states' authorities and by Europol. Eurojust's tasks include the initiation of criminal investigations, as well as proposing the initiation of prosecutions conducted by competent national authorities, particularly those relating to offences against the financial interests of the Union, the coordination of investigations and prosecutions referred to in point A, the strengthening of judicial cooperation, including by resolution of conflicts of jurisdiction and by close cooperation with the European Judicial Network. And the treaty provides that secondary legislation in the form of regulations will lay down arrangements involving the European Parliament and national parliaments in the evaluation of Eurojust activities. However, it's important to note that formal acts of judicial procedure carried out by the competent national officials. A new potential development introduced by Article 86 is the creation of the European Public Prosecutor's Office from Eurojust, whose remit would be to combat crimes affecting the financial interests of the Union. Now, the Stockholm Programme is the key driver behind judicial cooperation in criminal matters and civil matters. And it basically specifies the EU action on developing the area of justice, freedom and security over the following 5 years. So if you like, it's like a 5-year plan on the different areas they're going to work on. The Stockholm Programme sets out the European Union's priorities for the area of justice, freedom and security for the period 2010-2014. It aims to build on the Tampere and Hague programmes which preceded it. So the Stockholm Programme incorporates 6 main priority areas, including Europe of rights, Europe of justice, Europe that protects, access to Europe, Europe of solidarity, and Europe in a globalised world. Europe of rights. European citizenship must be transformed from an abstract idea into a concrete reality. And these are all objectives established by the member state governments, including the UK government. It must confer on EU nationals the fundamental rights including set out in the EU Charter of Fundamental Rights and the European Convention for the Protection of Human Rights and Fundamental Freedoms. EU citizens must be able to exercise these rights within as well as outside the EU, while knowing that their privacy is respected, especially in terms of protection of personal data. The Europe of rights must be an area in which citizens and their family members may exercise in full the right to free movement. Diversity is respected and the most vulnerable groups of people, children, minorities such as the Roma, victims of violence, etc. are protected, while racism and xenophobia are tackled. Europe of rights also provides that the rights of suspected and accused persons are protected in criminal proceedings, and EU citizenship promotes citizens' participation in the democratic life of the EU through transparent decision-making, access to documents, and good administration, as well as guarantees citizens the right to consular protection outside the EU. Now, the next objective of the Stockholm Programme is to create a Europe of justice. And the European area of justice must be realised throughout the EU. Again, these are objectives set by the member state governments. Access to justice for citizens must be facilitated so their rights are better enforced within the EU. At the same time, cooperation between judicial authorities and the mutual recognition of court decisions within the EU must be further developed in both civil and criminal cases. To this end, EU countries should make use of e-justice, information and communication technologies in the field of justice, adopt common minimum rules to approximate criminal and civil law standards, and strengthen mutual trust. The EU must also aim to achieve coherence with the international legal order in order to create a secure legal environment for interacting with non-EU countries. Stockholm Programme also recommends the development of an internal security strategy for the EU, with a view to improving the protection of citizens and the fight against organised crime and terrorism. The strategy will aim to enhance police and judicial cooperation in criminal matters, as well as cooperation in border management, civil protection and disaster management. The internal security strategy will consist of a proactive, horizontal and cross-cutting approach with clearly divided tasks for the EU and its countries. It will focus on the fight against cross-border crimes such as trafficking in human beings, sexual abuse, sexual exploitation of children and child pornography, cybercrime, economic crime, corruption, counterfeiting and piracy, and drugs. The legal framework for judicial cooperation in criminal matters is therefore complex, not without its critics, perceived as being a vital flanking tool in order to counter the security and public order risks inherent in having a free market which enables the free movement of people, including criminals and terrorists, are subject to various lockdowns. Over the next few years, it is likely to see a number of significant changes to the existing judicial cooperation in criminal matters framework. The enhanced cooperation procedure is likely to have an effect, although critics argue it will lead to a two-speed Europe. Whilst most people agree that judicial